The decision as to whether to opt out is really a business-based decision. It is a complicated system in many ways, and it does require a lot of business input because ultimately your patent portfolio is part of your business value.
I'm Katia Douglas, the Commercial Director of Pure Ideas, and I'd like to welcome today Dr Alex Povey, Senior Patent Attorney at our sister company, Avidity IP. Welcome, Alex, and thank you for joining us today. Would you mind giving us a little bit of background on your experience in the patent world, please?
Sure, thank you, Katia. It's a great pleasure to be here, and my first visit to Stratford, and I'm very pleased to be here. Thank you for the invitation. Yes, I've spent about 25 years in the patent profession, mainly in-house role in the pharmaceutical life sciences sector. I've specialised in the drafting and prosecution of patent applications for small molecules, new chemical entities as we call them, formulations and other pharmaceutical products. I've also spent some time working before the European Patent Office as a European patent attorney, working on oppositions, both defending patents and opposing third-party patents, and doing due diligence work, preparation of freedom to use opinions, and getting involved in the IP terms in contract and consortium agreements, and also in UK national litigation in the UK court, and being involved in litigation in the German courts too. Prior to joining the patent profession, I spent about 20 years in R&D. I'm a chemist by training, doing analytical chemistry, again in the pharmaceutical sector, where I spent a lot of time working with project teams, preparing documents for regulatory submissions.
So thank you, Alex. Wow, you've got some serious experience there that we can draw on, hopefully, today in what we're going to be speaking about. I mean, perhaps first of all, I should talk about briefly the relationship between Avidity, as I described it, our sister company, and Pure Ideas. Alex, would you mind just giving us an overview of the sort of sectors that Avidity covers for intellectual property?
Avidity handles the life sciences sector, so we can do anything from small molecule chemistry, formulation work, genetics, large molecules, what we call the biologicals, the biosector, macromolecules. We do basically anything to do with the life sciences sector, from small to large molecules, formulations, and biotech.
Right, and that's really, it plays really well to the sort of the strengths of the group as a whole, because Pure Ideas specialises in patent work in the engineering and emerging technology sectors, as well as having significant experience in trademarks, designs, renewals, and validations. I think what we've come to today to discuss is the significant change that is coming to the patent world. It's been coming for many, many years. I'm sure you'll tell us all about that as well, Alex. And that is the unitary patent and the unified patent court, two very distinct things, actually. And for those of our clients with a pending European patent, or a granted European patent for that matter, we will be covering why these two particular aspects are so important and why you really do need some advice from your patent attorney. So, Alex, when is the Unified Patent Court Agreement likely to come into force, and what is meant by the sunrise period?
Well, the agreement governs the introduction of the Unified Patents Court and the unitary patent system itself. As you said, Katia, this has been coming a long time. The date when the agreement is expected to enter into effect fully is the 1st of June. However, there's what they call a sunrise period, a kind of introductory period of the preceding 3 months from the 1st of March this year, which will allow the system, the processes to ramp up, if you like, in preparation for the opening day on the 1st of June. During that sunrise period, clients can make decisions as to whether they want to have their patents in or out of the system, get the IT systems prepared, and start getting their business arrangements in place, their ducks in a row, if you will, before we go live on the 1st of June.
which is really important that people are starting to prepare, isn't it, Alex? So if we start with the Unified Patent Court, Alex, can you explain to the listeners what is the Unified Patent Court and why is it important to clients who've got a granted European patent, and what should they be thinking about really?
The Unified Patents Court is a court, one of the first court of its kind in Europe, where it is truly a transnational court. It has jurisdiction over a number of EU member states. Its decisions are at once effective in all of those states, and it can act for both revocation actions and infringement actions. This is an important distinction between the European opposition system, which works basically as a revocation system. The UPC, the court system, the Unitary Patent Court, will have jurisdiction for revocation and infringement actions across the participating EU states. The Unitary Patent itself, again, is probably the first truly transnational patent in Europe. For the past 50 years, we've had the European patent system before the European Patents Office, and that's been very well established and very successful. But what that does is a patent application which is made before the European Patents Office on a regional basis. But after grant, the patent, when it's granted, is then split into a bundle of national patents. So you then choose which of the states you wish to have your European patent validated. Once that is done, then any post-grant matters other than opposition is dealt with by the relevant national court. So, for example, you have a European patent validated in the UK, and there's an infringement action that will take place before the UK court. The Unitary Patent Court, the Unified Patent Court system here is different, and it will have jurisdiction over European patents. They have not been opted out, and the new Unitary Patent. So the Unitary Patent itself differs from the current European patent in that once it is granted, it is at once effective in all of the current participating states, the current 17 EU member states. So it is one unitary right. It is enforced on a unitary basis by the Patent Court, the Unified Patent Court, and can be revoked on a unitary basis by that court. So it is therefore distinct from the current conventional European patent, which is dealt with after grant on a national basis.
Thank you for that, Alex. So how will the UPC have jurisdiction over my patents then?
Well, the position is by default it will have jurisdiction over unitary patents anyway. So if you have a new unitary patent, the Unified Patent Court will have jurisdiction over that patent, and there's no way out of that, as it were. That will always be the case. For conventional European patents, the Unified Patent Court will also have jurisdiction over them, along with national courts, unless that patent has been opted out or your patent application has been opted out of the system. So there has to be a positive decision made if you wish not to be part of the Unified Patent System, that you will opt out your application or your patent.
Right.
For conventional patents, I said that either the UPC or national courts have jurisdiction. It depends on which court is seized of an action. So if someone files a revocation against your non-opted out European patent before the Unified Patent Court, then that court has jurisdiction and the national courts do not. Conversely, if someone takes action in a national court against a non-opted out European patent, then the national court have jurisdiction, not the UPC. So it's a kind of who gets there first. But if your patent or application is opted out, then the UPC does not have jurisdiction. If you have a unitary patent at the other end of the scale, if you will, a unitary patent will always be under the jurisdiction of the UPC.
Okay, so there's a lot to think about there, isn't there?
The decision as to whether to opt out is really a business-based decision. It is a complicated system in many ways, and it does require a lot of business input, because ultimately your patent portfolio is part of your business value, and you will need to decide, do I want my patent to be in this new system or not? And that decision can really only be made in conjunction with a patent attorney and Avidity IP. Their patent attorneys are very, very skilled at providing this advice, but it needs to be done in partnership with the business. I think as a rule of thumb, if you're unsure about it, then the best decision would be to opt out of the system. But it's not clear cut, in as much as it depends on which side of the fence you are sitting. If you believe that your patent is likely to be attacked or revoked, then maybe you will want to opt out to avoid having that pan-territorial effect by the UPC. If you have a strong patent and wish to enforce it against a third party, you might wish to be in the system, whereas the infringement decision will work for you across all the territories. But it's not a one-size-fits-all decision. It's a very new area, and it will have to be. You will need to get advice both from your business and your attorney.
And I guess until some case law has built up in the Unified Patent Court, it'll be difficult to know which way some of these decisions will be made.
That's right.
Yeah.
The UPC will draw heavily on the existing European Patent Convention, the law on the European Patent Convention, and there is overlap there as to what the grounds of revocation are, for example. So the UPCA does refer to the EPC in some contexts. The European Patent Convention, the EPO, has a vast repository of case law. Both systems are civil jurisdictions, both being based in continental Europe. We would expect in the early days that maybe they will follow the kind of the EPO style decisions, but the court will be free to develop its own jurisprudence and its own case law. But in the early days, it is likely, we think, that it will tend to follow the EPO system as we know it. One of the fundamental ideas behind this unitary system is to avoid having conflicting national decisions. So there is a very strong drive there to have a consistent approach to the law, which will necessarily, I think, involve drawing on current case law, at least until jurisprudence is developed.
Okay. So it really is something that you need to talk to an attorney about and review in the context of your business and what you want to do in the future before you make any snap decisions.
Absolutely.
Yeah. Thank you. And in terms of the unitary patent itself, what exactly is it, and when do I need to decide about it? If I'm sort of looking at having a patent in Europe, when do you have to make those decisions?
We can make those decisions now, even though the sunrise period doesn't begin until the 1st of March. The EPO has, as from the 1st of January this year, put in place provisions where applicants can take steps towards selecting a unitary patent for their application. So although the system doesn't become live, as it were, until later this year, those decisions can be made now. Again, as I've said, that as to whether you make that choice or not should be done in conjunction with your attorney and your business partners. But we can start thinking about it right now as to make those decisions.
Yes. Okay. Thank you. So, Alex, you mentioned the countries that the unitary patent covers. Would you mind revisiting that for us so we understand better, who's covered by or which countries are covered and who isn't, and why that's important?
Sure. Going back to the European Patent Convention that's been around for 50 years, that covers well over 30 territories in Europe, some of which are not in the EU, some of them are. So the European Patent Convention is not derived from EU law. It's a completely independent system and covers countries, e.g. the Norway and now the UK, which are not in the European Union. However, the Unified Patent Court and the Unitary Patent System is an EU-derived system and only covers countries which are in the EU. This is why the UK, for example, is not part of the unitary system because of Brexit, so we are no longer in the EU. As the final court of arbitration in the unitary patent system was the CJEU, the UK said no, we're not having an EU court making decisions over the UK in any way, shape or form. So that was why we withdrew from the unitary patent system. Now, there are a lot of other EU states who could be in the unitary system but are not yet. One of the main ones being Spain, Poland, Ireland, Romania. So to the extent that there are EU territories or even EPC territories which are not in the unitary patent system, they will have to be validated separately in the conventional way on patent grant. So your unitary patent might well cover all of the states, the 17 current states participating in the unitary system, and then you will have to validate that separately in the individual non-participating states. Now, although the UK is not part of the unitary system, I think it's important to stress that European patent attorneys based in the UK do have rights of audience before the Unitary Patent Court. So although the UK as a country is not participating in the system, UK European patent attorneys who are qualified to act before the EPO do have rights of audience and can conduct work for the Unitary Patent and the Unitary Patents Court in the same way as, say, a German or a French attorney. So that option is still available. So don't think that because the UK is no longer in the system that we can't help. We certainly can, and we are entitled to help, and we will. So you talk to your UK-based European patent attorney, and you will get the same advice as anywhere else.
That's good to hear, actually, that we're not shut out from that system. No. And thank you for that. And what happens, Alex, once the sunrise period is over and the Unified Patent Court Agreement comes into force? What next?
Well, it remains to be seen exactly what the take-up will be for the new system, and what cases, what revocation or infringement actions are taken in the court, and what the uptake is really. It's hard to predict when the first real hearings will take place, because that's ultimately the test of any patent. Is not whether it's been granted or not passed muster with the examiner, but does it pass muster in the courts? And of course, that would be the acid test, if you like, of how the system will work. I think with any new system, there will be maybe some teething problems, some settling down will have to take place. It's very, very new for everybody. Although the judges for the Unitary Patent, the Unified Patent Court, have been drawn from expert judges from across the participating states. It's still very new in many respects, and it's hard to say what will happen next, any large events or when, and who will go first, if you like. So it's I kind of watch this space, if you will. Yes.
I mean, Alex, thank you. You've given us a great insight into what is really a very complicated subject. Alex, my thanks again for you sharing your knowledge on this important topic. If any listeners have any questions at all about the Unitary Patent Court or unitary patents or anything else related to intellectual property matters generally, and you'd like to discuss them, then please do not hesitate to get in touch using the links following the podcast. Thank you very much.
It's my pleasure. Thank you for inviting me. Thank you.
Thank you.